Hi, welcome to Laptop Radio. Today's topic is compliance with labor and employment law. We have Jonathan Longino, counsel from Perkins Coie here with us. Hello, Jonathan.
Hello, hello.
Hi, how are you?
Oh, I'm doing well today. Happy to be here, and thank you for having me on the show.
Welcome. Let's do an intro really quick before we dive into labor and employment law.
Sounds like a plan.
So what is your story?
That's a broad question. Professionally, I've been practicing labor and employment law for about 10 years now, and I've been with Perkins Coie for about 6. I focus my practice on labor and employment generally, which can incorporate a really broad universe of topics. My time is often split between litigation, some advice and counsel, mergers and acquisitions, and even executive employment agreements and restrictive covenants. My litigation practice is generally focused on wage and hour class action, though it also includes a number of individual claims such as harassment, discrimination, trade secret misappropriation, and employee privacy. The other half of my practice is very focused on advice and counsel, which basically means my job is to be responsive to clients whenever they call up with any issues that you can imagine with their employees. And I've heard the whole gamut, all the way from simple employee underperformance issues all the way to workplace violence and how to handle some pretty extreme misconduct by current and former employees.
Wow, that's awesome. So let's begin. So let me ask you a very fundamental question. What is the difference between employee and consultant?
Oh, that is the $64,000 question, so to speak. And unfortunately, it's one that doesn't always have a clear-cut answer. And to make matters even more complicated, you may have heard that California recently changed its test for who constitutes an employee and who is a consultant. Previously, we were under an old test called the Borrello factor test, named after a Supreme Court decision from back in the 80s. And was replaced recently with what's now called the Dynamex test, or the ABC test. But at the end of the day, while there are a number of legal nuances under both of those tests that can impact who is and isn't an employee, it really comes down to a matter of control. If the employee is controlling how someone performs services, or not the employee, but if the company is controlling how someone performs a service, then that person is more likely going to be considered an employee. But if, conversely, someone engages a person to just complete an end result, they don't really care how you get there so long as you get there. This could be you're commissioning a painting, you're asking for a bit of nuanced coding, or maybe you're reaching out to a consultant and saying, hey, can you give me some advice on your area of expertise? How am I supposed to handle this? Then that person is more likely considered a contractor. And what you may have heard so far is I keep talking in terms of more likely or less likely, and that's because there's a lot of gray area in what constitutes control. And at the end of the day, it's something that has led to a lot of litigation over the last few years, and is something that is currently being tested even up through this day.
Wow.
So unfortunately, I wish I could give you a straightforward answer as to who is an employee and who is a consultant, but at the end of the day, a lot of this operates in the middle. There are some jobs that are absolutely clearly this person is an employee. There are other jobs where absolutely the person is a consultant. But frankly, most of these relationships wind up having a little bit more nuance to them than just clear cut and dry answer.
And does it matter if there's an agreement between them or not?
Preferably, there's a written agreement. If I'm working on a contract, an agreement with a consultant, I'm certainly going to advise that we get a written agreement in place. But it's not necessarily required that you have a written agreement in order for someone to be a consultant. Really, the agreement, what that does, one of the best, most powerful things it can do is it can outline who has the right to control what, and who has the ability to control how this is done, how the services are performed. The technical term that you might hear if you're reading some of the case law is controlling what's called the manner and means by which services are completed. So if you're at a point where you're managing someone through what they're doing, maybe you're leaning more towards the employee end of the spectrum. And so that's where an agreement comes in helpful, because it says you don't have the contractual right to tell me how to do it. You only have the contractual right to tell me what the end result is going to look like.
Wow. So if you don't have an agreement, you could still be an employee or a consultant depending on the amount of control.
Yeah, and that's really what it comes down to. For instance, if I ask a buddy of mine who happens to be an expert painter and say, would you come over, I need my house painted blue. And I'm not going to tell him how to do it. I'm just going to ask, hey, come over and do it. And he comes in and says, sure, I'll do it for however much he's going to charge me. And at the end of the day, if my house is blue, then I'm not telling him, use this scaffolding, use this paintbrush, use this type of equipment here. I'm just requesting an end result that, even though there was no written agreement, that person should not be considered an employee. But that being said, again, a written agreement is always a best practice. It makes it much clearer and takes away some of that ambiguity that exists if you only have what's called an oral agreement.
So what are some of the top 5 illegal labor practices that companies usually do? And I just wanted to focus on not just big companies, but also startups. And I know that they're a little bit different.
So that's an excellent question, and I should clarify that my clientele ranges all the way from the brand new angel fund investment startup all the way through Fortune 100 companies. So I deal with companies across the spectrum in size and deal with a very significant number of startup companies in various stages of growth. One of the things that I get to see this from an interesting perspective, and now I don't know that I would think of it in terms of illegal labor practices that companies usually do. Now this may sound like I have rose-colored glasses, but almost every client I have, well, I guess it's helpful to think of it in this term. Companies are usually not monoliths. They're made up of people who are trying to do the best job they can and want to get the best result. And most people want to be able to go home and sleep at night with a clean conscience. Now, I'm not saying everybody does, but by and large, most people want to believe they're the good guy in their story or a good girl. So what I have is many of my clients, they want to do what's right by their employees. They just don't always know how to do what's right. And so many of the questions I wind up fielding are, how are we supposed to handle this? And which is why, frankly, it's really useful to get in touch with somebody who knows how to handle the compliance before something becomes an issue. But to answer your question as best as I can, if I had to identify the top issues that I wind up helping companies with, I'd break it down into a few groups. One, wage and hour compliance is something that companies, I don't want to say struggle with, but definitely come to me on a regular basis to try to figure out, how do I handle this? Now that could mean who's an employee and a contractor, but it can also mean, how on earth do I interpret all the provisions of the California Labor Code to make sure I'm complying with everything? Because paying someone is not necessarily as simple as as having an hourly rate or a salary and then providing them that hourly rate. It can become a lot more complicated than that. For your non-exempt employees, for instance, you might think, oh, if I worked overtime, it's just time and a half their hourly wage. But calculating the regular rate, which is technically what you need to use with overtime, can be very complicated depending on how an employee is compensated. Maybe they're a piece rate worker. Maybe they receive non-discretionary bonuses. Maybe they receive discretionary bonuses, commissions, etc. It becomes very complicated in figuring out how to do it right. So I spend a lot of time walking companies through the best practices there. Another area that we wind up dealing with a lot is, frankly, management issues, and helping to figure out, how does a company deal with an underperforming employee, and how do they appropriately manage them so that they either get the best performance out of that employee possible, or come to the conclusion that it's no longer working out. Yes, we do get questions related to employee misconduct. While most people want to do the right thing, people sometimes mess up. Now, it's not always the company that's doing it, but it's somebody within the company maybe mistreating a coworker, a supervisor mistreating a subordinate. That doesn't necessarily mean it's discrimination or harassment. It's just there's some sort of improper, unprofessional conduct going on. And helping to manage companies through that takes up a lot more of my time than you might imagine. But the big thing to take away from all that, though, is, again, I wouldn't say that companies are trying to usually do illegal things, but it's more trying to figure out how do we navigate through a set of complex personalities that are operating, and especially in a startup environment, operating with the high pressure of usually short runways before they run out of cash, and trying to make sure that you get an idea off the ground from a concept all the way to some form of marketable product or an exit to a purchase or whatever is going to take place next.
Awesome.
So I don't know if I answered your question directly that way, but you usually wind up having these types of issues. Oh, also, intellectual property issues wind up coming up quite a bit. Who owns what, and how to make sure the employee who's departing the company doesn't walk off with the secret sauce and take it to a competitor. How to make sure that you don't have somebody coming in and inserting third-party intellectual property from their former employer. That comes up quite a bit, especially in the startup context, because when you're dealing with a startup company, your intellectual property is often the most valuable thing you have.
Mm-hmm. And what's the relationship between IP and wages issue? So you mentioned wage, employee management, or management in general, and then IP. So if for startups especially, if an employee or an independent contractor or someone without a contract has contributed to IP but hasn't been compensated, is that an issue there? So that's two issues in one.
So I'm going to use the lesson that most of us learned in kindergarten. Two wrongs don't make a right. If your employer or whoever has engaged you to be a consultant doesn't pay you, there are recourses to handle that, to address that. Most of the time, a lot of that comes into accidents that take place. Very rarely is someone acting maliciously when it comes to underpayment. But if somebody doesn't pay you, that doesn't give you the right to say, I'm not going to take this intellectual property I created for you and use it as my own. Again, just because somebody did something incorrect possibly with your wages doesn't mean you then in turn have the right to say, all right, well then I'm going to take this intellectual property and go off to your competitor.
Yeah, and it depends on whether
and
you
in fact,
something that assigns the IP.
Mm-hmm. If they've assigned the IP, then the intellectual property has been assigned to the company. Now, at the end of the day, if you have an employer if you have concerns, yes, you should certainly take those to the employer. But just because somebody did something wrong to you, or you perceive that someone did something wrong to you, doesn't give you the right to turn around and take their intellectual property. And your recourse is to try to right the wrong that was done against you, not to create another wrong that then just makes everybody look bad.
Yeah. And what recourse do people have if they are discriminated against? I just wanted to move a little bit there and just really speak generally about discrimination.
Mm-hmm. That's a good question. Now, one thing that I'm sure most listeners know is that there is a very robust set of laws on both the state and the federal level that provide protections for employees. And there are a number of ways of enforcing those rights. But before you can even get into that, it's helpful to understand what we mean when we say discrimination or harassment or any of these other terms that provide individual rights in the workplace. A lot of people use that term very broadly, and in the back of their mind, they're really using it informally to mean someone acted rude towards me. And what surprises a lot of people when I discuss this is I have to note there's no rule prohibiting being rude or a jerk in the workplace. If you're an equal opportunity jerk, that's completely legal. I'm not encouraging that in any way, shape, or form. I don't think it's a good way to run a workplace, but it's not illegal necessarily. Harassment and discrimination, that's really conduct that is based on what's called a protected characteristic. Now, that's a legal term that usually means something that's unchangeable about a person and has nothing to do with how they perform their work. Common protected characteristics, some of the most well-known and recognized would be, race, gender, religion, sex. There's a federal list of protected characteristics. There's a broader list here in the state of California that goes beyond and covers concepts such as gender expression, gender identity, sexual orientation, characteristics which are not necessarily protected at the federal level. And then you have further protections that local cities have engaged that cover an even broader set of protected characteristics than necessarily what would be covered at the state or federal level. So, but even if it's not necessarily illegal discrimination or illegal harassment, I still strongly recommend, and I tell this to my clients all the time, that it is absolutely a best practice to create a workplace where everyone can succeed. So if you see or are experiencing conduct that you think could be discriminatory or harassing, frankly, I think the best first step is to try to resolve it within the workplace. Now in California, and I keep referring to California because I am a California employment lawyer, and California has its own unique set of employment laws that are a little bit broader than the rest of the country. But in California, you have the right to report the wrongdoing that you perceive to your supervisor, or if you're not comfortable taking it to your supervisor, to report it to whomever the company designates as someone who can receive reports of wrongdoing in the workplace. This usually is human resources or whoever handles the HR function, especially if you're at a startup and you don't have a full HR department yet. And in that situation, it's usually the easiest way to resolve a bad situation before it rises to the level of illegal discrimination or illegal harassment. It gives you the chance to stop something before it becomes a major problem. Now, sometimes it may be a simple fix. As I mentioned, companies are not monoliths. They're made up of people, and these people are going to have the same sort of disputes in the workplace that they might have in their personal life. And so sometimes what is perceived wrongdoing just winds up being a miscommunication or two people who are just not communicating clearly with each other. Sometimes it's you have a manager who has a hard time giving constructive criticism, or even frankly, sometimes an employee who has a hard time receiving constructive criticism. Sometimes you have two people who just need to be separated. Clearing the air is not going to resolve the situation, but it's not necessarily is a conduct that rises to the level that somebody needs to be fired. We just separate people and everybody can go about their day. And yes, sometimes after that report, somebody might need to be fired. And there are protections to ensure that anybody giving a good faith report of wrongdoing in the workplace won't be retaliated against. So I would encourage anybody who feels they have wrongful conduct to start off by seeing if we can fix it at the very beginning. Now, yes, sometimes it can't be handled internally. And a person who feels they've been discriminated against, their second recourse is to go to either the state or federal agencies that are charged with investigating these types of claims. You know the Equal Opportunity Employment Commission, Equal Employment Opportunity Commission, or the EEOC, as well as the California version, the Department of Fair Employment and Housing, or the DFEH. And of course, if you believe you've been discriminated against, you do have the right to file suit. Though again, at the end of the day, usually the best way to get to a quick and satisfactory resolution is to try to fix it before it becomes too big of an issue.
Wow. Thank you for that. I think it's awesome to hear that people that on the employer side that that we need to determine what is discrimination, what is rude behavior, and what are some of the best practices and what to do if that were to occur. How about the
Well,
wage?
and one follow up on that, just to give some examples, some of the types of questions we're getting more frequently these days have to do with it's a very charged political environment. And what side of the political spectrum you side on can lead to very strong reactions in other employees in the workplace. And I wind up fielding questions from people who are concerned about, so-and-so's telling me that this is their political belief, and I find that objectionable. And at the end of the day, what you are finding out is, this is perhaps we need to teach people to use common respect or to avoid certain topics in the workplace. Some things just aren't appropriate in the workplace. But we find that somebody coming in and saying, I'm being discriminated against because this other person, I'll give you two examples. These are generic examples that are an amalgamation of numerous experiences, so this is not specific, but we might have somebody coming in and saying, I object to being taught that I have to be understanding of everybody's sexual orientation because my religion says that this is improper. Well, you know what? We do have to respect everybody's sexual orientation. It's a protected characteristic, but we also want to make sure that we're helping that person understand that the communication is not intended to be discriminatory, and that we're not doing anything that at the end of the day forces that person to forces any party to feel that they're in a workplace where they can't be able to perform to their best of their duties. But it also means we might have to clear the air with that person that, no, this is we're an equal opportunity employer, and we want to make sure that that everybody has a chance to perform their job to the best of their duties. And on the flip side, we will sometimes hear people complaining that they don't enjoy hearing that somebody happens to support that they don't enjoy hearing that somebody happens to support, for instance, the Trump presidency. And that's perfectly fine to be able to say you don't enjoy somebody's politics, but we all have to live with each other and work next to each other. Now, of course, with the caveat that doesn't necessarily mean you have the right to go around spouting dialogue that is necessarily going to be considered discriminatory or otherwise in violation of any protected characteristic, which again includes nationality, race, gender, sexual orientation, etc.
Yeah. Yeah, I agreed. And what recourse do we have if you're a victim of wage thieves?
Now I'm going to give you another very lawyerly answer here. Say wage theft. It does, and that's right. The lawyerly answer to every question is it depends. And here it depends on whether or not you're dealing with actual wage theft. Now there are two kind of categories of wage issues that are kind of subsumed into the idea of what is wage theft and who are wage thieves. The first, wage theft, is generally a very specific intentional act of trying to deprive someone of wages that are otherwise admittedly due. It does happen, sure, but it's very much so an infrequent occurrence compared to the other category that people think of when they talk about wage theft, and that is, what do they mean when perhaps someone feels that they have earned wages and that hasn't been appropriately paid out to them. Now, that doesn't necessarily mean the company did something intentionally wrong, that they were trying to act as a thief, but there could be disputes over whether or not a person's been paid appropriately. Now, if a person has a concern about how they're compensated, I would again, and I don't want to sound like a broken record here, but I would say an informal resolution is going to be the quickest way to get a resolution. So again, going to the company, talking to the payroll department, and trying to figure out what happened is almost always the fastest way to get money in your pocket. Because at the end of the day, if you believe that you have not been paid wages you're owed, the main concern is making sure that you get that corrected. And the fastest way to do that is to go to payroll and say, hey, I thought I worked 37 hours last week, and instead you paid me for 36 hours. Where's the extra hour? What's taking place here? Now, companies, generally speaking, are not trying to take wages from people after they've earned them. Most of the time, it's a simple miscalculation. People transpose numbers when they're entering payroll into the system. Now, thankfully, with automation, we have fewer and fewer of those transposition errors, but they still do occur, and mistakes can happen. But if you bring it to your employer, most likely it's going to get fixed relatively quickly. Now, if, as with discrimination, if that doesn't resolve it, yes, you can escalate it. The next step would be to take it to either the California Labor Commissioner or the Department of Labor, whatever entity is charged with enforcing the wage and hour laws and where you reside and work. Or, of course, you can always file suit if you believe that you've been improperly paid, whether it was wage theft or just a wage and hour miscalculation, whatever. But again, I would say the fastest way to get a resolution is going to be trying to see if you can resolve it informally before it turns into a 2-year wait for a lawsuit to resolve.
Yep. And for consultants and independent contractors, they could also file claims.
They are entitled to file a claim, though in many circumstances that's going to be more of a breach of contract claim.
Yeah.
Because if you're a contractor and you believe that you're owed certain not wages, but owed certain payments because of services you provided, your claim would be a breach of contract as opposed to a wage claim.
Yep. And what are some of these employment and labor best practices, especially for startups?
Talk to someone like me early on. I'm not actually kidding that much. It's a little tongue-in-cheek, and I'm not trying to turn this into an advertisement of.
I completely agree with you.
But it's frankly, you're early, especially with a startup, and this is one thing that I tell my clients as much as I can. Your early practices, how you interact with your employees, the policies you put in place, what you do at the very beginning, that's creating the DNA of your company. That's creating what's going to grow into who you're going to be. And if you see that early on with a culture that isn't open and communicative, if you see that early on with a culture that is top-down management, these aren't necessarily illegal things, but it's not going to create the best culture for your company. Now, some companies do have those types of cultures and succeed and do great. But in many companies, you need to think about the DNA at the very beginning, and it does include how you interact with your employees, how you interact with your service providers, your consultants, your contractors. And it's best to make sure you get that done right at the beginning. Now, 3 specific things that I usually focus on when I'm trying to help my clients build their DNA and partner with them early on. The first is get compliant employment policies in place. That means get an employee handbook from an employment lawyer or from your PEO, and actually read that handbook too. Make sure you go through it and have a basis for understanding what these policies that we're recommending for you are. And ask questions if you don't understand or you don't agree or you don't know why the policy is written the way that that was offered to you, because that can help you engage in how you're going to handle things in the workplace. 2, I would definitely recommend that you create a culture of respect and clear communication. A startup is a pressure cooker. It is high demand, high intensity, and a lot is on the line for a lot of employees and a lot of people who've invested in it, have invested their time, their energy, their money. And so you can't necessarily get rid of the fact that there's a lot of stress in a startup environment, but you can try to create safety valves, so to speak, escape valves, so that stress doesn't build up to the point that you start getting people pointing fingers at each other or people claiming wrongful conduct in the workplace, to make sure that everybody, frankly, has a good place to work. And that leads to that leads to my last point of what I usually tell my clients, and that is make sure everybody's acting professionally. And if you have bad apples in there, people who, even if they're great performers, but they're creating poison in the workplace, think very thoroughly as to whether or not you want them there. They may not be acting illegally, but just consider whether you want that in your culture.
Yeah, because it basically affects the entire culture. I mean, it impacts the entire workplace.
Exactly, and it could cause somebody to get rubbed the wrong way, and then even if it wasn't necessarily illegal, the way the person was walking around being a jerk, it could at the end of the day cause somebody to think, maybe I have a claim, and now you have to figure out, is there a claim, was there not a claim, how do we resolve this situation? It's better to start at the beginning and avoid the problem before it happens.
And it's important to, I mean, these best practices are really useful because like you said, it is the DNA of the company that you wanted to have a very strong and solid foundation for your startup, not only for due
Exactly.
but also for culture.
Oh, and one other thing I would recommend is it is helpful periodically to have an employment lawyer and other types of lawyers come in and just take an audit on your policies and practices beyond just the handbook that maybe we hand you at the very outset. Take an audit on making sure that everybody you've engaged and you put them in the right bucket. They're appropriately an employee, they're appropriately a contractor, they're appropriately exempt, non-exempt. Usually a lot of startups wind up getting it right, but it doesn't hurt to take a peek under the hood every once in a while and make sure everything's running appropriately.
So startups don't really have a lot of money. So how much does that cost, and how do startups start with that?
Well, certainly startups don't have a ton of money, and I'm not recommending spending an entire budget on legal. I would recommend partnering with lawyers who deal with a lot of emerging companies and startups and venture-backed companies, because lawyers who practice in that area are aware of the fact that not only do you have to be correct, you have to be thorough, but you also have to be very concise and very to the point. You don't have a lot of time to spend agonizing over it's a little bit this, it's a little bit that. You have to take your best assessment and move on to the next piece and do so quickly. What does the cost look like? That's going to vary by every employer. It's going to vary by every company depending on company size, how many states and jurisdictions the startup is located in. There is no one size fits all, and it's something that you wouldn't just call up and say, hey, can you do a full audit? It's the sort of thing where you would periodically check in with your counsel and say, hey, what would this look like, and what would it take to give a quick look under the hood to make sure we're doing things correctly? And sometimes you just want to spot check. Maybe you're pretty comfortable on a lot of things, but you just want to spot check. Hey, how am I handling this? Am I handling this okay? Is this the right way to do it? And the companies who are asking those questions, not every day, not even every month, but who are asking those questions with some frequency, are the companies that are going to avoid stepping into pitfalls.
Yeah, those are really awesome insights. Thank you, Jonathan. I have one last question for you, and that last question is, what is that one advice that you wanted to provide for the community? And it could be anything from employment to labor to startups, just anything that you have.
I'm going to shamelessly steal from an old movie, but from Bill and Ted's Excellent Adventures, and that is be excellent to one another. More accurately, a better way of phrasing it would be diligent and respectful in what you do in the workplace, and everything's usually going to work out okay. Now, does it always work out okay? No. And are there issues that come up? Yes. And that's why there are the lines of communication and avenues that we talked about today. But the companies that I have some clients who have policies. They may be informal, but they're effectively no jerk policies. I've heard more colorful ways of phrasing it. But the idea is, look, we don't tolerate people being a jerk in what they're doing. You need to be nice to each other. And that tends to avoid most of the issues that people come across. A corollary to that, I guess I would say, is be mindful of what you don't know. Because maybe you think you're being nice to each other. And this has been part of what's gone on in with the whole Me Too movement. Some people are acting absolutely abhorrently, and famous examples in the news. But there are also a significant number of individuals who just don't understand that communication that you might find acceptable may not be acceptable to someone else, or it may hit somebody who has had a different life experience in a way that you don't understand. So be aware of what you don't know and be open to having that ignorance taken away and trying it again. Be excellent.
Thank you, Jonathan. Those are really awesome advice.
Well, thank you, Michelle, for having me. I really appreciate it.
Thank you for your time. I'll talk to you soon. Bye-bye.
Bye.